Industry in Constitution of India. The Constitution of India contains several provisions relating to industries, primarily on regulating industrial activity, protecting workers' rights, promoting economic development, and ensuring social justice. The provisions are spread across the different part of the Constitution. Industry in Constitution of India. Industry in Constitution of India. The Constitution of India contains several provisions related to industries, primarily focusing on regulating industrial activities, promoting workers' rights, promoting economic development, and ensuring social justice. These provisions are spread across different parts of the Constitution. The Constitution of India has guaranteed some fundamental rights to the citizen and has also laid down certain directive principles of state policy for the achievement of a social order based on justice, liberty, equality, and fraternity. Article 14 lays down that the state shall not deny any person's equality before the law or equivalent protection of law. There shall be equality of opportunity to all citizens in matter relating to employment, appointment to any office under the state. People have the right to form associations, union, traffic in human being and forced labor, and employment of children in factories or mines or other hazardous work is prohibited. The directive principle, though not enforceable in any court, are nevertheless fundamental in the governance of the country, and it shall be duty of the state to apply those principles in making law from time to time. Article 14 Equality before law. Article 15 Prohibition of discrimination on the grounds of religion, race, caste, sex, and place of birth. Article 16 Equality of opportunity in matter of public employment. Article 17 Abolition of untouchability. Article 19 Protection of rights regarding freedom of speech and freedom of association, etc. Each of the above rights form the basis of industrial relation policy in Indian context. Labor is in the concurrent list on which both the state as well as the center has power to make laws. Article 254 has been enacted to clarify the position normally as laid down in clause 1. In any case, any repugnancy between union and the state legislation, the legislation of the union shall prevail. To this, there is one exception embodied under clause 2 of Article 254, where a law enacted by the state with respect to the matter enumerated in the concurrent list reserved for the consideration of the President has received his assent, such law shall prevail in the state, and provisions of that law repugnant to the provisions of an earlier law made by the Parliament or any existing law with respect to the matter have priority over the central legislation. Article 39, 41, 42, and 43 have special relevance in the field of industrial legislation and adjudication. In fact, they are the substratum of the industrial jurisprudence. Article 39 accentuates Article 39 accentuates the basic philosophy of idealistic socialism, which is enshrined in the preamble of the Constitution, and provides a motivation force to the directive principle by laying down that the state shall direct its policy towards equal pay for both men and women. Article 14 lays down that state shall, within the limit of its economic capacity and development, make efficient provision for securing the rights to work, to education, and to public assistance in case of unemployment, old age, sickness, and disablement, in order in cases of undeserved want. Article 42 enjoins the state government to make provisions for securing just and human condition of work and for maternity relief. Article 42 makes it obligatory for the state to secure by suitable legislation or economic organization or in any other manner to all workers, agricultural industrialists, and otherwise, or a living wage, condition of work ensuring decent standard of life and full enjoyment of leisure and social and cultural opportunities. Article 43 capital A makes it obligatory on the state to take steps by suitable legislation or otherwise to secure the participation of worker in the management of undertaking in industrial establishment. Though the directive principles are not justiciable, they are a sheet of anchor in the legislation by the center and the state of the field of welfare of the working class, and it is observed by the National Commission on Labor and its report. In accepting the directive principle of the country is committed morally and ethically to see that governance of the country is carried on with a view of implementing this directive principle in course of time. A brief discussion regarding the extent to which provision had been adopted and enforced in our country will be in order. Social security is guaranteed in our constitution under Article 39, 41, 43. The Employer State Insurance Act 1948 is pioneering piece of legislation in the field of social insurance. The benefit provided to the employers under the scheme are sickness benefit and extended sickness benefit, maternity benefit, disablement benefit, dependence benefit, funerals benefit, medical benefit. All the benefit are provided in each cash except all the benefits are provided in cash except medical, which is in kind. The administration of the scheme is entrusted to an autonomous corporation called the Employees State Insurance Corporation. The Employees Provident Fund and Miscellaneous Provisions Act 1952 and the Maternity Benefits Act 1961 are also social security measures to help fulfill the objectives of directive principle of our constitution. The Provident Fund scheme aims at providing substantial security and timely monetary assistance to industrial employees and their families. This scheme has provided protection to employees and their dependents in case of old age, disablement, early death of a breadwinner, and in some case other contingency. A scheme of family pension cum life insurance was introduced with a view of providing long-term recurring financial benefit to the families in an event of the members' premature death while in service. The Employees Provident Fund organization is in charge of three important schemes. Via the Employees Provident Fund scheme, the Employers Provident Family Pension scheme, and the Employees Deposit Linked Insurance scheme. The maternity benefit scheme is primarily designed to provide full wage and security of employment. They enable a female employee to get maternity leave with full wages at least for 6 weeks and 6 weeks after confinement. The object of the Payment of Gratuity Act 1972 is to provide a scheme for the payment of gratuity to employees employed in factories, mines, oil fields, plantation, port, railway, shop, and establishment All employees who have rendered minimum 5 years continuous service in above mentioned establishment are entitled to gratuity at the time of superannuation, retirement, resignation, death, or if they leave their job due to accident, disease, disablement. Under the Act, under the Act, employees are required to pay gratuity at the rate of 15 days wages for every completed year of service, subject to maximum of rupees 10 lakh. Besides social security benefit, efforts have been made to provide ample opportunity for employment, worker education. The Apprenticeship Act of 1961 was enacted to supplement the program of institutional training by on the job training and to regulate the training arrangement of industry. Fundamental Rights Part 3. Article 19(1)(g) Right to practice any profession or to carry any occupation. Trade or business restriction under Article 19(6). The state can impose reasonable restriction on the right to protect public interest and regulate industries, example licensing or state monopoly. Article 14. Right to equality ensures no discrimination in industrial policy and prevents arbitrary action by the state affecting industries. Article 23. Prohibition of forced labor, which has direct implication for industries employing bounded and exploitative labor. Directive Principles State Policy Part 4. These provisions guide the state in making policy to promote equitable industrial development and workers' welfare. Article 39. These provisions guide the state in making policy to promote equitable industrial development and workers' welfare. Article 39 directs the state to ensure that ownership and control of material and resources are distributed to serve the common good and prevent concentration of wealth. Article 41 Right to work and public assistance in case of unemployment. Article 42 Provisions for just and human condition of work and maternity relief. Article 43 Promotion of living wages, decent working condition and participation of workers in industrial management. Article 43 capital A encourages workers' participation in management of industries to foster harmony and cooperation. 3. Part 4A Fundamental Duties. Article 15(1)(a). It is a duty of the citizen to strive towards excellence in all spheres, including industrial development, to raise nation's status. Distribution of legislative powers. 7. Schedule. The division of subject between the union and the state list provides a framework for legislative power over industries. Union list. List 1 includes the regulation of industries like atomic energy, railway, defense, oilfield, mines, and major ports. State list includes regulation of industries specific to states such as minor industries and trade. Concurrent list. List 3 includes matter like trade union, industrial dispute, factories, welfare of labor. Both union and state legislature on this subject. Special provisions for central industries. Article 31 Capital C protects law implementing directive principles like equitable resource distribution in industry for being challenged on the grounds of violating fundamental rights under Article 14 and 19. Article 246A provides for special legislative power related to goods and service tax impacting industrial taxation and trade. 6. Industrial dispute and labor welfare. Constitutionally, labor welfare is a significant aspect of industrial regulation. Provisions under the concurrent list allows law like Industrial Dispute Act 1947, Factories Act 1948, social justice aspect of labor law derive their inspiration from Constitution. These provisions collectively aim to balance industrial growth and labor welfare and social justice within India's constitutional framework.